Welcome everyone to Lawfare 101, episode 1. Thank you for joining us tonight. We are CODEPINK San Diego, and tonight we want to talk about something that can be intimidating for even the most experienced activists, and that is lawfare, which is the use or misuse of legal and governmental systems to intimidate, silence, punish, or financially drain political activists and movements. Across the country, people organizing around Palestine, human rights, anti-war activism, anti-ICE, and opposition to U.S. military policy are increasingly encountering lawsuits, subpoenas, investigations, threats, sanctions, restrictions on speech, and attempts to characterize political activism as unlawful or discriminatory. For example, from Colombia, we had Mahmoud Khalil, who was kidnapped right in front of his pregnant wife, missed the birth of his first child. We have Francesca Albanese, the UN Special Rapporteur for Human Rights in Gaza, and she's been sanctioned. She cannot use her bank accounts. She cannot come to the U.S., even though her child is a U.S. citizen. Campus groups, people couldn't graduate. People were threatened constantly for speaking out. So how can we protect ourselves and our organizations without being intimidated into silence? And tonight we want to talk about just the very, very basics of lawfare. And this is not a legal counseling session. We will not be giving any legal advice. This is just, just some information that we want to share. And let's hear from our guests. We have Austin and we have Kirstin. Austin, would you like to introduce yourself?
Good evening. My name is Austin Lucas, Esquire. I am a former practicing immigration attorney and now a counselor of law students and a proud supporter and member of CODEPINK and Veterans for Peace.
Thank you.
I'm Kirstin Jarstad. I'm a civil litigation attorney in California, and I support the activist movement, so I'm here to say what I can say to help.
Thank you, Kirstin. So let's get started. Austin, what is lawfare?
Okay, right to the heart of it. Lawfare is the strategic use or misuse of legal processes in order to burden, pressure, or disadvantage your adversary beyond the ordinary merits of the claim itself. It is a key aspect of modern warfare. The term lawfare has existed for a long time, but it was popularized in the early 2000s by a Major General Charles Dunlap. He is a retired Air Force JAG who accused American enemies of turning to international tribunals when they could not overcome our own military technology.
Okay. So tell me how effective is this?
I think the greatest mark of its effectiveness is how organizations and people respond to it. Specifically, the United States government. In their imperial aims, they are afraid of lawfare. It is why you're seeing an increase in the abandonment of international law. When the U.S. projects their global hegemony and want to defend themselves, claiming it's for national security, what they are really doing is trying to avoid violations of international law, so that way they can stand above the law. That is why we see us abandoning, defunding, and withdrawing organizations such as the International Criminal Court. Most evident, in February 2025, Donald Trump signed an executive order where we would review, defund, and withdraw from 66 international organizations, 31 in the UN and 35 non-UN. This is similar actions taken when we withdraw from the Paris Agreement and the JCPOA, where we do not want people relying on our treaty violations to stop us from enacting our will.
Gotcha. Okay, so how would this apply on a more individual or smaller scale? How does this affect individuals such as activists?
All right. Very important for everyone here to know, unless you happen to be a world superpower and we don't know about it. The most common expression of this is slap suits. That is strategic lawsuits against public participation. Slap suits have the main function of trying to bury their enemy in legal costs. You also see it in other tactics such as forum shopping, where they try to find a friendly judge and have the case heard in front of them, or discovery abuse, where thousands of documents are being released and then have to be spent reviewing in order to actually advance the case. You also do see it going the opposite way. When you see corporations greenwash their products, label them as eco-friendly, misrepresenting themselves, sometimes organizations will use this tactic to bring litigation, and it's not necessarily about winning the case, but it's about creating bad publicity for the corporations. So it is a very all-encompassing strategy. A very important thing to recognize, though, is governments and corporations will try to paint the picture that it's only the weaker individuals who are responsible for lawfare, but that is not true. The evidence is enormous to show how these corporations and government entities use the will and might that they have to suppress small voices, which we see even now in our own CODEPINK matters.
Our own community, that's right. We have activists with a lawsuit that is being waged by Jones Day, and they have endless pockets, and on an individual level, they make it nearly impossible to fight back. So how, what the goal here, they want to chill our speech, which as activists, we can take that as a push to keep going, because obviously we're having an effect and they have to keep us quiet. So if we were lying, if none of this mattered, they would not feel any need to do this kind of stuff. So tell me, what is the chilling effect? Tell me about that.
So the chilling effect is a very important thing to understand when we're talking about protected speech, because it doesn't mean just necessarily that you will be in prison for what you say, but it is the forces that convince you not to say anything. So the chilling effect specifically is when an individual, organization, or group is prevented from exercising their legal right, leading to self-censorship, restraining the information you share, or abstaining from activities that are otherwise protected. I think you should all ask yourself, have you ever held back from commenting on the Charlie Kirk assassination or on Luigi Mangione's case because you were worried about blowback from your employer? That means you have been chilled. If you have ever avoided ordering certain books because you were worried you were going to be tracked, you have been chilled. If you were ever worried about leaving the country and would you be allowed back in because of your activities, if you decided not to go peacefully protest because you were worried about being sued, such as the impact it's having on CODEPINK activists, then you have been chilled. And that is a serious, egregious violation of your protected rights.
Right. So, do you have any recent examples of chilling?
There are enormous amounts of recent examples. I would like to go over some more modern but historical examples just so we can show the context here. It'll come to no surprise to everyone that the civil rights movement was a framework for lawfare and chilling speech. Most notably in a couple of Supreme Court cases. New York Times versus Sullivan was a case where an Alabama official sued the Times for minor factual errors. Then an all-white jury awarded them $500,000 in damages. After that, a number of other officials followed suit and kept bringing these cases. The goal there was not to be made whole and get damages. It was to scare the northern press away from covering matters in the South. Similarly, in NAACP versus Alabama in 1958, the state sued the NAACP not to win on the merits, but to try and force them to release their membership lists, which would have inevitably led to white terrorism. It's this that violated their freedom of association and creates a chilling effect from discouraging people from getting involved, because what if a lawsuit happens and all of a sudden you are exposed? So those are some examples that have laid the framework for what we have now. Recent examples, I will highlight a few. One of them has now risen from these civil cases where they're suing for money to criminal charges, such as those against journalist Don Lemon. Don Lemon was covering a peaceful protest at a church that featured a pastor who was an ICE official. Now, 7 individuals involved in the action have been charged with crimes, and so was Don Lemon for conspiracy and obstruction. Now, I think it's important to recognize here that anyone can accuse their opponent of lawfare. It is a tactic to obfuscate what's really happening. So we need to look for extraordinary acts, things that are atypical. In Don Lemon's case, the then Attorney General, Pam Bondi, personally directed these arrests of an individual citizen. She turned to social media and blasted him for being a part of this coordinated attack. And we saw magistrate judges refuse to charge these folks. We saw them refuse to approve warrants. We saw appellate courts uphold those decisions. And it was just a relentless pursuit by the federal government that led to these charges eventually going to a grand jury. Now, that is how you reveal the ulterior motive. This is not just about community safety. This is a vendetta, and that's how you recognize lawfare in its place. Some other examples. Donald Trump has personally sued civilly CBS and ABC. Now, let alone the massive conflict of interest that he is manning these departments of justice and such. He sued, received $16 and $15 million settlements respectively in order to pressure them from giving negative coverage. He used the wheels of government, the leverage he had in regulatory matters, to convince them to stop covering him in certain ways. We see similar actions taken against law firms. There have been executive orders, there have been memos, they're targeting law firms for who they might have represented in the past, whether they represented Democrats, whether they represented people like James Comey, and those law firms are being chilled to not take cases like that where they will lose their federal security clearance and things like that. So this is how they're using the law and the legal processes beyond just courts. Now, one of the most important cases right now is the Prairieland defendants. On July 4th of 2025, there was a noise demonstration in solidarity with immigrant political defendants in Texas that ultimately did lead to a non-fatal shooting. Now, as a result of that, 22 different individuals have been charged, and so far 8 have been convicted and sentenced. They were sentenced to a combined time of over 450 years. The shooter got 100 years, and each of the other individuals were given over 30 years of imprisonment for what they were involved with, which was a peaceful act. Now, they were all being accused of being a part of this elaborately funded network called Antifa. They relied on any belief in leftist philosophies, the possession of anti-police or anti-ICE zines, and even the fact that they were all wearing black clothing as evidence that they were terrorists and designated as such. So I want to repeat that opposing fascism and deploying common tactics like wearing all black does not make you a terrorist, but still you might bear the full brunt of federal prosecution and excessive incarceration. And this type of hostility we see in other matters, whether that is individual campuses who are attacked for Palestine solidarity, whether that is states like California and Minnesota right now being denied congressionally mandated Medicaid funds. Now, claims of fraud and these things, these are just terms used in media coverage, but there's no actual substantiation of those charges. But the goal isn't to win, it's to cripple the enemy and scare off future challengers.
Yeah, even the guy that moved the zines was given 30 years. Isn't that...
Wasn't even there.
He wasn't even there. So definitely chilling. Recently, we have come to know about what is called the FACE Act. And it's been used in the past quite a bit. Never for the purpose that it's being used for now until just recently. So can you tell us about the history of this FACE Act?
Thank you, Amy. Absolutely. As you said, recognizing its history and origin is how you can detect if it has been corrupted and being used in other ways. So the FACE Act was the result of an escalating wave of violence against women's health clinics, reproductive justice centers in the 80s and 90s. We're talking about bombings, arsons, kidnapping, and even murder. And the states were not prepared to handle that level of activity. At best, they could charge people with trespassing and disorderly conduct, if they did at all. A lot of local jurisdictions just did not pursue those courses of justice. So the feds stepped in, and President Bill Clinton in 1994 signed into law the FACE Act to have a more uniform and proportionate response. I think it's also worth noting that in addition to reproductive centers, this also applies to houses of worship because, no surprise, black churches were particularly targeted in similar matters. So the FACE Act was designed to protect women's health clinics and has been extended to houses of worship.
Okay. So what exactly does it do?
So the FACE Act is relatively straightforward. It has 4 elements. 1, it prohibits force, threat of force, or physical obstruction done with the intent, that intent is very important, to injure, intimidate, or interfere with anyone or attempt to interfere, injure, or intimidate because they are obtaining or providing these services in the health context or wishing to practice their faith in houses of worship. I'll also add in, it includes intentional property damage because property rights are extremely important to the American government. The FACE Act allows for both criminal prosecution and also civil suits for damages, which we can talk about more later.
Okay, how does that intersect with activism?
So immediately upon passage, the constitutionality of the FACE Act made its way up to the Supreme Court because of potential vagueness of what type of activity was prohibited and concerns over First Amendment protected rights. Now, the Supreme Court has upheld the FACE Act because it's not regulating the content of your speech. What you're saying is not what they are regulating. They are regulating your conduct, the acts of obstruction or injuring. So because of that, it is content neutral and has been allowed to proceed. Now, they have also evaluated what does it mean to intimidate or possibly injure somebody. And they use a totality of the circumstances test where they look at all the factors involved to determine, is the person a true threat? What they are saying, is it a true threat? For example, one of the cases involves someone yelling to a doctor over 50 times about another doctor who was murdered because of their abortion services. That rose to the level of true threat, and that is unprotected. But hostile speech, that is protected. You can still say vile things, but it's that test of, has it resulted in a true threat? Is there a likelihood of someone executing unlawful violence? I think it's also important to note, what does physical obstruction mean? Because it's easier to determine if someone has been injured. But physical obstruction, that does not mean that you've made the way for someone to enter a building totally impossible. It means that you've made it unreasonably difficult or hazardous for them to try and enter. And even slow down tactics, like walking in front of cars trying to enter, that has been deemed an obstruction that meets the standard for the FACE Act.
Okay. Tell us, what is the difference between criminal and civil law? A lot of people, like myself, might not know exactly what the difference is.
That's very important because, as we said, the FACE Act applies in both fields. So our legal system is essentially divvied up into 2 tracks based off of how we hold someone accountable, who brings the case, what's at stake, and what has to be proven. And that is the civil and the criminal field. So let me start with criminal law. Criminal matters revolve around offenses that are deemed against to be a society as a whole, not just the victim. Murder. Even though there is a victim, we as a society deem it an offense to our society. That's why we see the people versus OJ. It's because the case is brought by the government, a prosecutor, a district attorney, or an attorney general against a defendant or co-defendants. Important components to criminal law is you need actus reus and mens rea. Actus reus means a guilty act, and mens rea means a guilty mind. It's equally important what you do and why you do it. The same reason you might see in murder cases. When you premeditate something, it's different than a manslaughter that was an accidental killing. Same impact, but the guilty mind changes what you're charged with. Another important feature for criminal law is you have to be proven beyond a reasonable doubt. That is the standard that judges or juries have to meet. And that's because of the outcomes. Criminal law, you face imprisonment, high fines paid to the state, probation. These are all aimed at punishment deterring you and others from doing this again, rather than actually compensating the victim. And because your risk of losing life and liberty are so great, your constitutional protections are higher. And we'll talk about that a little bit later as well.
Okay. Let's see. So you went over the definitions of criminal versus civil. What do we need to know as peace activists? We have been watching a genocide for 3 years. We're watching the militarization of the police. We're watching surveillance cameras be put up all over. How can activists get ahead of this? How can we be armed with the knowledge to keep us safe?
So the most important thing for peace activists, for citizens of the world, is to know your rights and to invoke them. If you don't invoke your rights by saying them loudly, saying them clearly, they can easily be ignored. And frankly, they can be ignored even as you do invoke them, but it does give you protection down the line. My number one piece of advice would be for people to do their own research into what this is. There's a number of Know Your Rights material you can find simply by Googling. I would turn our guests to the National Lawyers Guild as an organization that focuses on political dissent and protecting it. I'd like to cover a couple of what those main ones would be. The First Amendment. Anyone heard of that before? That's what protects free speech, freedom of religion, your ability to assemble, to associate, and to petition your government. For peace activists, this looks like turning to traditional public forums like the streets, sidewalks, and parks, where the government cannot really impose upon you that many limitations. It is smaller in those public places. Now, if you're in a private business, there's a lot of restrictions on what you can do. But in these public forums, they're greater. You generally can only be restricted in the time, place, and manner of your protests, such as it's midnight and you're using megaphones, or this is a safety for traffic concerns, in which case they can limit that as long as it is not limiting based off the content of your speech, but it's because of the conduct. Recording police and government officials when they are in action of their duties, this is another First Amendment right that you have. I think this is an important time to recognize and give a little bona fides to California, which helps to protect people from the civil side of this from anti-SLAPP cases. So when you are being sued civilly with SLAPP cases, California has a lot of civil protections that allow you to get out of the case early and potentially win back attorney's fees for what you cost you. So California and a few other states have strong laws that help peace activists from those civil suits.
What does SLAPP stand for?
So SLAPP, again, is I'm going to look this up, Strategic Lawsuits Against Public Participation. So it's the civil side of how we can stop peace activists. And let me go over a little bit about civil law, too, because that's what we also face as individuals. Civil law, different than criminal, is the dispute between two parties. Just person A versus person B, company A versus person B, and people versus government agencies. So anyone can bring a civil suit as long as they have the resources to do so. The standard is lower, not beyond a reasonable doubt, but a preponderance of the evidence. More likely than not, this person did it. No one is going to prison for civil suits, but you will be facing monetary damages. You could be enjoined, or an injunction could be ordered against you, preventing you from doing something, or you could be forced to actually do something, such as complete the terms of a contract. So that is how the civil side applies to people, and SLAPP cases are those civil suits trying to chill, but also get some type of damages. A huge difference with these civil cases is who's bringing the case. It's anybody. So there's even a further level of public protection removed from that. When we have public cases brought criminally, we can rely on prosecutors. Now, prosecutors have a vast amount of discretion, which cases they're going to bring, which strategies they're going to use, what sentencing they're going to push for. So this is another example of where you should be investigating so you can determine, is this legitimate? Recently, we've seen a lot of illegitimate acts. And as a result, we have seen a wave of federal and career prosecutors resign. For example, in New York City, there was a quid pro quo, and the corruption charges against Eric Adams were dropped, and so prosecutors resigned because they didn't want to be a part of that. January 6th insurrectionists were pardoned, and attorneys resigned. We have reprioritized how our Department of Justice enforces civil rights, and even have JAG attorneys be converted to immigration judges. And so that level of atypical behavior shows actions that are out of line with the typical prosecution of crimes. Now, I know I'm going on a little bit of a long wind, but I do want to revert back to our amendment protections. The Fourth Amendment. This is what protects you from unreasonable searches and seizures. Typically speaking, police need a judge's approval or a warrant to search your persons. Otherwise, they need some exigent circumstances like danger. Now, you are allowed to be patted down, mainly for the officer's safety. But something you need to remember is that you do not need to consent to a search. And you should say that. I do not consent to any search. That should be a oft-repeated phrase when you are involved with officers. Now, if you are arrested, you will be searched as part of the process. Another important right is your Fifth Amendment right. That protects you from self-incrimination. I plead the Fifth. I am not going to tattletale on myself. It also gives you the right to due process. Before you are put in prison, you have processes of a judge and jury. This is something very important when we see immigration cases not getting their due process and getting deported. If anyone doesn't have due process, you don't have due process. And what that looks like is the right to remain silent and demand a lawyer. Again, something you should be repeating often.
Just a quick note on that Fourth Amendment. One example of fighting back against this, it just happened to Max Blumenthal. His phone was searched extensively coming through the airport, and so there's now a federal lawsuit defending his Fourth Amendment right not to be searched.
Excellent example. And even though in the moment, if the police is going to search you, they're going to search you, and you should avoid violence. But it means when the case gets in front of a judge, all that evidence can be thrown out. And the Sixth Amendment is what guarantees us that right to a fair trial, an unbiased jury, and one of the most fundamental and visionary aspects of American jurisprudence is the right to a lawyer. Everyone charged with a crime has a right to a lawyer because of the Sixth Amendment. When you are invoking these rights, something important to remember is that the goal is to end your interaction with law enforcement as quickly as possible. So, the first thing you want to be asking is, am I free to go? If you are, and you can safely leave, then you should leave. If they say anything other than yes, you ask, am I being detained? If they say anything other than yes, you should say, I do not want to speak, I want to speak to my lawyer. That's how you invoke your rights, which is very important to protect yourself down the line. And that's what peace activists need to know.
Thank you, Austin. That was very comprehensive. I appreciate that. Thank you. Kirsten. Yes. Do you have any? Welcome, first of all.
Thank you. And thank you, Austin. That was really informative.
Very informative. Before we start, do you have any initial comments that you would like to make?
Again, this is for educational purposes only. If you have questions about a particular case, talk to an attorney. What I want people to take away from this is that when someone is sued, they should speak to an attorney. Litigation is time-consuming, expensive, really complicated, and while people can represent themselves, it's not usually recommended. It's very difficult to prevail against an opponent who has an attorney. So if you can get counsel, get counsel. If an individual is sued and they ignore, and then we're talking about civil law, we're going to go through some civil litigation, nuts and bolts. If an individual is sued and they don't answer the lawsuit, they run the risk of what's called a default judgment, which means that they can't defend themselves in court. All elements of the complaint, all factual claims are deemed admitted, and the plaintiff only has to prove their damages. So if a party is sued and they don't respond, they run a high risk.
Don't ignore it, folks.
Yes. So that's my big picture.
So why don't we start getting down to the nitty-gritty of law? Can you tell us an overview of our legal system?
Yes. So in California and every other state and U.S. territory, there's a state system and there's a federal system. And within each state court system and federal court system, there are civil courts and there are criminal courts. So that's the big picture.
Okay, so how are California courts organized?
So the terminology is important because people get really confused. Federal courts and state courts apply different rules, sometimes different law. So the first question you always ask is, what court are we in? In the California state court system, trial courts are called superior courts. Each county in California has its own superior court system. The California superior courts apply their own rules of civil procedure and their own rules of evidence, which are different than those that are applied in federal court. There are similarities, but the details are important. States can apply state law, of course, state statutes and state case law. Generally speaking, state courts can also apply federal law, for example, the FACE Act. The reverse is not always true. Federal courts cannot always apply state law. So that's an important consideration in analyzing the status of a case. In the California the California state court system, there are essentially three levels of courts. There's a trial court, there's a court of appeal, and there's the California Supreme Court. And state court decisions in the Superior Court can be appealed to the Court of Appeal, and sometimes when it's warranted, they can go all the way to the California
start
Supreme
at
Court.
a trial court.
Yes.
Then you go to appeals. My
Yes.
side doesn't, no, we're
The
not
loser
having
can
it.
appeal.
Loser can- And then it goes up to the Supreme.
It can. Review at the Supreme Court level is discretionary,
Okay.
generally speaking. The exception is in California cases, death penalty cases are automatically appealed to the California Supreme Court, but those are the only cases that are guaranteed review by the California Supreme Court.
Okay.
Good to know.
And tell us how federal would be organized.
So federal courts are organized similarly. The terminology is different. Federal trial courts are called district courts. There are 4 districts in the state of California. There's the northern, the southern, the eastern, and the central district. The lawsuit that we were talking about that's happening in San Diego with San Diego activists was filed in the southern district of California. Similar to, like, federal courts apply federal rules of civil procedure the same way I said that state courts apply state rules, and they also apply the federal rules of evidence. So that can be good or bad depending on who you are and what the circumstances are. Federal courts can always apply federal statutes. They cannot always apply state law. So for federal courts are courts of limited jurisdiction, so you cannot always file in federal court. You either have to have a federal statute or you have to have what's called diversity jurisdiction, which is where you have essentially parties from different states. In those cases, they can usually be filed in federal court. Again, there's the 3 levels in federal court as well. There's the trial court, courts of appeal, and the U.S. Supreme Court. District court decisions can be appealed to the Circuit Court of Appeals. And so all district courts are organized into regional circuits. California is in the 9th Circuit with 8 other western states: Alaska, Arizona, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington.
Okay, so it's geographically.
It's geographically organized, yes. And so a district court decision, a final decision at the trial court level can be appealed to the circuit, the 9th Circuit, if you're in California. And in theory, a decision from a Circuit Court of Appeal can be appealed to the U.S. Supreme Court, but review is discretionary and very rare. Fewer than 100 cases are reviewed by the U.S. Supreme Court every year.
Really, per year.
Yeah.
So if we can we start at the first step of a lawsuit, the trial court?
Yeah, so civil lawsuits are filed in civil court at the trial court level, either in the Superior Court or the District Court. Trial judges oversee all aspects of a case up to trial. So they hear motions, they decide discovery disputes, and other, like, for example, they might order a party to testify at a deposition. They oversee settlements. Most cases do settle without going to trial. So trial courts can be involved in oversight of settlements. If a case doesn't settle, it goes to trial. And even though there are jury trials and there are also bench trials, a bench trial just means that a judge is
The final decision.
the judge is making all the decisions.
Okay.
But even in a jury trial, the judge has a tremendous amount of power. They decide how the jury is instructed, how the law is applied. They decide what evidence comes in or doesn't come in, which is an issue in the Prairieland case where the courts excluded evidence that the shooter was acting in defense of another. So keeping that evidence out probably decided the outcome of that case. So that would be a question for the Court of Appeal. When you have admissible evidence or evidence that arguably should have been admitted and was excluded and had a prejudicial outcome on the case, the Court of Appeal can essentially reverse or order a new trial. But I'm getting ahead of myself. So when a trial court conducts a trial, there's witness testimony, there's oral argument, admission or exclusion of evidence. The trial judge determines how the law applies. The trial court instructs the jury. And once a judgment is final, the losing party can appeal the decision, if it's in state court, to the California Court of Appeal, and if it's in federal court, to the district court, the circuit court.
Before we get up to the next level of the Court of Appeals, can you tell me who decides whether or not it's just a bench or a jury?
So parties typically have a right to a jury trial, even in civil cases, which would be under the Seventh Amendment.
Okay.
Sometimes they choose to waive the right to a jury trial. Sometimes, depending on the complexity of the case or how they think a jury is going to respond to them, if you're in a particular area where maybe the jury pool isn't favorable to your point of view, you might rather have a bench trial. So parties can waive a right to a jury trial.
Okay. And then if we move up to the next level, if we're ready for that, the Court of Appeal.
So courts of appeal, they don't retry cases and they don't hear new evidence. They look at the record from the trial, which is typically going to be a trial transcript. It's going to be the evidence that was admitted or excluded, the way the jury was instructed, the way the law was applied. And essentially the Court of Appeal is supposed to determine, if the trial was fair. If there was a prejudicial error, the judge didn't conduct the trial correctly according to the law, and it likely had a negative outcome on the trial, then the court can order a case to be retried, which is called a remand. The Court of Appeal does not retry the case themselves. They send it back to the trial court, and then there's a whole new trial. The court can also reverse a decision. There are different levels of review depending on what is being challenged at the trial court level, but that's the big picture. And Court of Appeal decisions can become binding precedent on the lower courts, on the trial courts. So the decisions that are made at the Court of Appeal can have very substantial and significant ramifications. After an appeal,
Wait, tell us what that means. What does that mean? If
binding precedent?
Yes, please.
So if the Court of Appeal decides that a certain law means a certain thing, then that principle gets applied to other cases.
So in another case, lawyers will go back and they're going to look at this case and be like, well, look, it was this way.
Yes.
So
Yes, they will cite to other similar cases. And typically in California, we have such a large population and so many courts and so many litigants that usually it's really rare to have a question that has not already been decided. But it happens.
Okay.
Yeah.
So moving on to the next level up.
Yeah, so after an appeal is final, the parties can attempt to appeal to the California or the U.S. Supreme Court. The California Supreme Court is the final and ultimate authority on California law, and including in the California Constitution. the U.S. Supreme Court is the ultimate authority on federal law and the U.S. Constitution. Like I said earlier, review is discretionary. The judges have to vote to accept the appeal of a case to the Supreme Court, either the state or the federal Supreme Court. Usually they accept review because there's an unresolved area of law where there's some confusion in the lower courts as to what a law means. Or sometimes it seems to be for political reasons, which technically it shouldn't, but it appears that way sometimes. And the decisions at the Supreme Court level are binding on lower courts, trial courts, and courts of appeal have to follow the Supreme Court decisions.
Let's go over some of the basics with the vocabulary. There's so many new terms. There's so many things to remember. Tell us, where do we start?
So in a civil lawsuit, the party that files the initial complaint is called the plaintiff, and the party who is being sued is the defendant. You can have a cross complainant where a defendant can turn around and sue the plaintiff back. And in that case, the defendant becomes a cross complainant and the plaintiff becomes a cross defendant. So it can get a little complicated.
Like an Uno reverse card.
Yes, the Uno reverse card. That's hard for me to say.
And then, so we have plaintiff, we have defendants. What are DOE defendants? What does that mean?
Yeah, so DOE defendants are interesting. They are an unidentified defendant in a case. So, for example, if a plaintiff is in a person's in a car accident and there's multiple cars and they don't know the name of one of the drivers, they can file a complaint and they can name a DOE defendant. And once they identify who the DOE defendant is, then they can amend their complaint to identify the correct defendant. These are treated differently in state court versus federal court. In California courts, it's very routine. You just file an amendment to the complaint. The judge doesn't have to approve it. And they have 3 years from the date of filing the initial complaint to identify the DOE defendant. And during that time, the statute of limitations is paused. So the DOE defendant filing puts a pause on the statute of limitations. I could talk about that in a minute. Federal cases are different. In federal cases, a plaintiff has to get permission from the court, from the judge, to amend a complaint to name additional defendants. And the statute of limitations continues to run during that time. So they're not as routine. Naming no defendants in federal cases are not as routine, although I think they're becoming more common.
Do you want to tell us what some of the documents are filed? What are those called?
You know what? I'm going to jump back really quick to the statute
sure.
of limitations because I had mentioned that previously and I didn't explain it. So a statute of limitations is, in most cases, a party has a limited amount of time in which they can file a lawsuit if they were allegedly wronged. And the amount of time that they have depends on what the underlying claim is. And we took, like, in a personal injury case, like going back to the car accident case, a party has 2 years from the date of injury to file a complaint. And if they're 1 day late, the court can throw out their lawsuit. So statute of limitations are a really important defense that defendants invoke in both federal and state lawsuits.
Okay. Thank you. Do we want to touch on what the documents
Yeah. So pleadings frame the issue for the court. A plaintiff files a summons, which identifies who the parties are, the plaintiff and the defendant. A complaint identifies the facts and the legal claims. And the defendant then files an answer, which is typically a denial of the claims that the plaintiff stated, and then a list of affirmative defenses, like the statute of limitations that I mentioned. And you can have a cross complaint, which was in the defendant, sues the plaintiff back.
Okay. And then let's go on. I think we are starting to run short on time. So
Okay, well, let me jump. I want to jump to the anti-SLAPP motion that Austin had mentioned earlier. So anti-SLAPP motions are a mechanism that a a defendant who is being unfairly targeted for their free speech or other protected activity can file a motion with the court to dismiss the lawsuit on the basis that it's just filed to like chill their speech or other protected activity. The plaintiff then has to show that there's a likelihood that they will succeed. And if the court determines that there's a likelihood that the plaintiff will succeed, then the court can allow the case to continue. If the court does not find that there's a likelihood, then they'll dismiss.
I do want to mention we do have the chat open. So if anybody has questions, please go ahead and put your question in the chat and we will try to answer them as best we can. So we'll wrap this up, but do you want to close out with something?
Yeah. So this was a brief 10,000 foot overview of the civil litigation. There's a whole lot more I can share. Litigation is expensive, it's time consuming, it's stressful, it's technical, it's complicated, and it advantages the rich and the powerful at the expense of regular working people. Lawfare tactics are being deployed to silence activists, and we can, by supporting activists financially or in other ways, we can help ensure that they continue to have a voice. And there is a Chuffed account, I believe, in the chat that you can donate to if you want to support activists.
Thank you. We have to remind each other that you have to keep showing up. The more that they go after activists with this lawfare, the more we know that it's working. And we just have to keep showing up. So we know we're within our rights, our First Amendment rights. And we just want number one, the genocide to stop. Our taxes should stay here, not go to genocide. And Austin, do you have any questions that we have from the chat?